Hello, everyone, and welcome back to our third and final portion of the University of San Francisco's Law Review Symposium. Our final webinar will feature today's keynote address, delivered by nationally renowned constitutional scholar and lawyer, Dean Erwin Chemerinsky. When I began research for the symposium several months ago, Dean Chemerinsky's work on free speech on campus is the piece that solidified my interest in free speech as the symposium topic. You cannot study American constitutional law without the work of Dean Chemerinsky, and I'm so honored to welcome the author of my favorite course textbook to USF. Erwin Chemerinsky is Dean and Jesse H. Choper Distinguished Professor of Law at UC Berkeley School of Law. Prior to assuming this position, he was the founding dean of UC Irvine School of Law and a professor at Duke Law School, University of Southern California Law School, and DePaul Law School. Dean Chemerinsky is the author of 14 books and over 200 law review articles. He frequently argues appellate cases, including in the United States Supreme Court. In January of 2021, he was named president-elect of the Association of American Law Schools. So without further ado, I will turn it over to this year's keynote speaker, Dean Erwin Chemerinsky. Thank you so much, Dean Chemerinsky.
Thank you so much for that incredibly kind and generous introduction. It's truly my great honor and pleasure to deliver the keynote speech for this impressive symposium. I wish that I could be with you in person. I'm still sheltering at this point and appreciate you willing to allow me to speak by Zoom. I want to talk this afternoon about the challenges of free speech for the 21st century. You've already had two wonderful panels on aspects of this topic. What I want to do is touch on the same topics that they did, but also look more broadly at the question of what are the real challenges of speech as we're now 20% through this new century. As I was preparing the talk for today, it caused me to pause and think about what would have been said 100 years ago if in January 1922, there had been a symposium and the focus had focused on free speech challenges in the 20th century. There was relatively little free speech jurisprudence from the Supreme Court as of January of 1922. And what existed in terms of Supreme Court decisions was very supportive of the government's ability to restrict expression. There was certainly not robust constitutional protection for freedom of speech. In 1915, in Mutual Film Corporation versus Industrial Commission of Ohio, the Supreme Court held that the First Amendment didn't provide protection for movies. And this led, throughout most of the 20th century, to local governments having censorship boards with regard to movies, something I'd heard of for any other medium. It wasn't for decades until Burstyn versus Wilson that the Supreme Court overruled that decision and held that films too are a form of speech safeguarded under the First Amendment. 3 years before 1922, in 1919, the Supreme Court handed down its first decisions with regard to freedom of speech under the First Amendment. All supported the government's ability to punish expression. The cases all involved prosecutions under laws adopted during World War I, the 1917 and 1918 Espionage Acts, and the cases all involved instances of people who were engaged in speech that the government found dangerous to the war effort. Perhaps the most famous of these cases, and I'm sure you studied it if you looked at First Amendment in law school, was Shank versus the United States in 1919. It involved a man who circulated leaflets in which he argued that the military draft was unconstitutional as a form of involuntary servitude. His leaflet said, quote, "Do not submit to intimidation." His leaflets had no identifiable effect. Nonetheless, he was convicted and sentenced to 10 years in prison. This was the case where Justice Oliver Wendell Holmes said, free speech isn't absolute. There's no right to falsely shout fire in a crowded theater. So Justice Holmes articulated the famous clear and present danger test. Yet Shank's speech seemed the antithesis of falsely yelling fire in a crowded theater. there was no clear and present danger upheld. So if we had been together in 1922, we would have talked about free speech in light of these cases from the prior decade. It certainly wouldn't have given us confidence in terms of where the law was going to go with regard to freedom of expression. And yet, the 20th and the early 21st centuries have witnessed enormous growth in Supreme Court protection for speech. We now know, for example, that content-based restrictions on speech must meet strict scrutiny. They must be necessary to achieve a compelling purpose. We know that civil liability for speech must meet First Amendment standards. New York Times versus Sullivan in 1964 held this. It was emphatic that the First Amendment protects the right to have open and robust debate about those who hold and run for public office. We know that there's a constitutional right to use at least some government property for speech purposes, public forums. And we know there's a whole host of decisions in the Supreme Court protecting aspects of free speech, like protecting against compelled speech, requiring that the government have a compelling interest if the government is going to compel expression. We know that the Supreme Court has protected a right to speak anonymously. The Supreme Court has protected conduct, like election spending is a form of speech, and so on. As important as the decisions of the Supreme Court in the last century have been, even more significant have been technological changes with regard to speech. In 1922, movies were a fledgling technology. Movies with sound were just on the verge of being developed. But in the years and decades that followed, radio, television, the internet, social media all developed. I would suggest to you that in at least some ways, we are now in the golden age for freedom of speech. Let me suggest some reasons for this conclusion. First, the development of the internet and social media have democratized the ability to reach a mass audience. It used to be that if you wanted to reach a large audience, you had to be rich enough to get a broadcast license or own a newspaper. Now, any of us who has a smartphone, or even just access to a modem in a library, can immediately reach a mass audience. In 1969, in Red Lion Broadcasting versus Federal Communication Commission, the Supreme Court upheld the fairness doctrine, and the right to reply law is applied to the broadcast media. The Supreme Court talked about the inherent scarcity of the broadcast spectrum. But no longer is scarcity a problem with regard to the media. There's infinite possible channels for communication, whether it's over the internet, social media, or whether it's over cable and satellites and the like. It's worth pausing to realize what a profound change this is to expression. Throughout world history, the problem was scarcity in terms of the modes of expression. There were only so many printing presses. In modern times, there are only so many channels for radio and television. Now scarcity is no longer the issue. And it's interesting to hear calls for regulation of the media, including proposals in Congress, based on the proliferation of sources of information. A second reason we're in the golden age of free speech is the immediate access to enormous quantities of information. Think of the things where to research before, you need to go to a library. But now you can just go on your laptop or go onto the internet and you immediately find the answer. When I was in law school, which was before Westlaw and Lexis, if I wanted to read cases, I'd have to go to the law library and pull the books off the shelf. I would have to go to the digests to find cases in other jurisdictions if I was trying to do national research. Now, of course, we all have access in law schools to Westlaw and Lexis on our computers. The immediate access to information goes far beyond that. I'm sure the experience of my family at the dinner table is typical of that throughout the country. So often when we'll be having discussions where there is a factual answer, in my family, it's often about sports trivia, we immediately can have somebody pull out a phone and look it up and resolve the dispute. We have access to the great libraries, the great museums across the world, just through our smartphones or our laptops. We have immediate access to infinite quantities of information. And of course, this too is crucial to the values that underlie the First Amendment. A third reason that I think we're in a golden age of speech is we have media that don't respect national boundaries. It's very difficult for any government to exclude information from its population. We saw this a while ago now when there was the uprising in Egypt, and the government is trying to stop the uprising, decided to close off access to the internet. But people with satellite phones were still able to get it and still able to have information. Now, this doesn't mean that totalitarian governments won't still try to cut off information, but the reality is it's impossible now because of the existence of the internet and social media. But while there are all of these benefits in terms of free speech, the very benefits that I've described also cause challenges with regard to expression. So what I want to talk about this afternoon, as I said, is the challenges I think we face in dealing with the First Amendment in the 21st century. I want to identify 7 challenges that I think are quite important. The first is the problem of false speech and misinformation. False speech and misinformation isn't unique to our times. There's always been the danger that inaccurate information will be spread. False things might be said that are injurious to people's reputation. Think of defamation law. It's always been about protecting people's reputation from public dissemination of untruths. And yet I think that the internet and social media have in kind changed the problem with regard to false speech and misinformation. It's so easy to immediately disseminate false information through the internet and social media. There's a permanence to information over the internet and social media that's also unique. It used to be that if a newspaper published a false story about somebody, in a couple of days, that newspaper would be in the bottom of a birdcage. To be sure, people could still access the newspaper, but they have to go to the library and find the microfilm or microfiche. Now, the false statement in the newspaper could circulate and cause grave harm to reputation. But compared to now, where once something is on the internet, it is virtually impossible for it to be cleansed. And so there is a permanence to speech, including false speech, that's different from what we've ever seen before. The problem of false speech goes even further than this. I'm particularly worried about so-called deepfakes, where by digitally altering images, it's possible to create very believable presentations that are completely false. I've seen deepfakes that have Barack Obama saying things that he never would utter. We've seen deepfakes in the political realm. We've also seen deepfakes where some would take the images of celebrities and then put them into sexual situations that are quite embarrassing. There's no doubt that false speech and misinformation can create great harms. If free speech had no effects, we wouldn't protect it as a fundamental right. We protect speech precisely because it can have and often does have impact. Those effects can be positive, but we've got to acknowledge they can be negative. Misinformation about vaccines, the dangers of COVID can cost lives. Misinformation can wrongly decide elections. The assumption of the First Amendment is often captured in the metaphor of a marketplace of ideas. Perhaps it can be traced back to John Stuart Mill. Certainly you find it expressed in an opinion of Justice Oliver Wendell Holmes dissenting in Abrams. Justice Louis Brandeis expressed this. It's the notion, let all ideas be expressed, and the false ones will be refuted by the true ones, and ultimately truth will emerge. This is a very romantic notion, but why believe it? For all, why believe when false things are said that there will be the counter speech? Even more important, why believe that the counter speech will be heard and believed? People tend to select listening and hearing what they already believe. The internet and social media make that even more so. It's so easy for all of us to just choose to listen to that which we think going to be our beliefs. If you're conservative, you probably listen to Fox News. If you're liberal, you probably listen to MSNBC. Say the same thing about the websites that you follow. So why believe that the marketplace of ideas will reach others? But even if ultimately you believe that truth will emerge from the marketplace of ideas, think of the harms that can ensue in the meantime. If people don't get vaccinated, they can get sick and sometimes die. People don't get vaccinated, we're likely to spread the disease to others. So there, the false information that exists in social media, and it's rampant, about vaccines can really have an effect. The First Amendment doesn't provide us very good answers with regard to false speech and misinformation, which is why I say it's one of the real challenges of the 21st century. There are times when the law allows false speech to be punished. False and deceptive advertising is not protected by the First Amendment. Perjury, lying in court under oath, is not protected by the First Amendment. But there are other places where the Supreme Court has said that the First Amendment safeguards false speech. Most famously, in New York Times versus Sullivan in 1964, the Supreme Court said there has to be protection of false speech. So freedom of speech has the breathing room it needs in order to survive. A more recent example of that is a case from just a decade ago, United States versus Alvarez. It involved a federal law, the Stolen Valor Act. They made it a federal crime for a person to falsely claim to have received military honors. Javier Alvarez, at a local committee meeting, declared that he had won the Congressional Medal of Honor. It was a lie. Alvarez was prosecuted under the federal government for violating the Stolen Valor Act. The Supreme Court declared the Stolen Valor Act unconstitutional. Justice Anthony Kennedy wrote and talked about the need for First Amendment protection for false speech. He quoted from the language that I just mentioned from New York Times versus Sullivan. And the court struck down this federal statute, emphatically talking about the need to have protection for even false speech and misinformation. But how are we to balance the importance of making sure that people get true information with these decisions that protect even some false speech? How will the courts deal with false speech and misinformation in light of the internet and social media and what we've seen? I do not think that current doctrines, First Amendment law, begin to provide an answer. I think it's one of the most important challenges of free speech in the 21st century. Second, speech can cause great harms, especially as it can reach a mass audience. I'm here going beyond false speech and misinformation, and I want to talk about the harms that speech can cause. And again, the inadequacy of current law and the need for law to develop in the 21st century. As I already said, and is familiar to all of you, speech can cause benefits, but it can cause harms too. I mentioned defamation, false speech that injures reputation that's publicly disseminated. For each of us, our reputation is something we develop over time and preciously guard. but our reputation can be destroyed quite easily by false statements that are widely circulated. There's a benefit that the internet and social media have democratized the ability to reach a mass audience, but there's also real harm if what's sent out to that mass audience is false information about a person that's very damaging to reputation. We saw so many instances where this is so. Or think about the mass dissemination of information that invades privacy. We each have information that we want to keep secret from the world. There's some things about me that no one, not even my wife, knows, not even my children. There are other things about me that I've shared only with my wife. There's some things that I've shared with my closest friends. And then you go on almost in concentric circles to that which I share with the world. But if you think of the inner circles, the most private information, what if someone obtains it? And what if they then circulate it over the internet and social media? My privacy is forever lost. No lawsuit can cure that loss. There's no way, to use the adage, to put the toothpaste back in the tube. And we've certainly seen such invasions of privacy used as weapons against people. You should probably know there's even a name for this: doxing. And often activists subject to this by an opposing side. Often students, others are subjected to this as a way of public embarrassment. Here too, the law has not yet dealt with this. It doesn't provide an answer for how do we balance speech rights against privacy rights. But to take one more example, where the internet and the social media create a unique problem, but we don't have an answer, and that's harassing and bullying behavior over the internet. The Pew Research Institute has done a number of studies about this. It's found, for example, that 41% of adults say that they've experienced some harassing or bullying over the internet. 59% of teenagers say that they've been bullied or harassed over the internet. 33% of women under the age of 35 say they've been sexually harassed online. We know, for example, that bullying or harassment can occur over the internet and social media in the school context. One of the panels that the symposium has already had focused on the Supreme Court's decision from last June, the Mahoney Area School District versus BL. The United States Court of Appeals for the Third Circuit in that case held that the First Amendment prevents schools from punishing any speech that occurs outside of school over social media. It's a very purist position, very speech protective. The United States Supreme Court agreed with the lower courts and protected the speech of Brandy Levy over social media. But Justice Breyer's opinion, and it was an 8-1 ruling, said that schools can punish speech that occurs out of school over social media if it's bullying, harassing. Justice Breyer also gave the example of cheating. But how do we balance the speech rights of students with the need to protect against bullying and harassing in the educational context? If you look for an answer in Justice Breyer's opinion, you'll search in vain. He simply says that schools can punish speech over social media if it's bullying, harassing, but he doesn't give us any criteria or any test to use or any way to approach this. A few years ago, I argued a case in the United States Court of Appeals for the Fourth Circuit that raised exactly this issue. It was Feminist Majority Foundation versus Mary Washington University. Mary Washington University is a public school in Virginia. It was considering campus whether to allow Greek life, fraternities and sororities. And 3 women wrote an op-ed in the campus newspaper saying, the presence of fraternities on campus is correlated with more sexual violence against women. Those women were then targeted by a vicious bullying campaign over then social media platform Yik Yak. Over 700 messages were sent to them and about them. Some of the messages threatened them with rape and murder. They went to campus officials and asked the campus to do something. The campus said, "This is anonymous speech over a social media platform. We can't do anything for you." In fact, the campus posted on its website that it would not take any position and could not do anything when it was anonymous speech over social media. The feminist majority organization, on behalf of these women students, sued Mary Washington University. It said that this speech constituted sexual harassment and the university was violating its duties under Title IX of the Civil Rights Act. Title IX, as you may know, says that educational institutions receiving federal funds can't discriminate based on sex. And this includes they cannot be deliberately indifferent to sexual harassment. The United States District Court ruled against the students and in favor of Mary Washington University. The district court said this is anonymous speech over social media. I argued the case in the Fourth Circuit, and I won. The Fourth Circuit said that colleges and universities have a duty under Title IX to prevent sexual harassment of students. What these students were subjected to is clearly sexual harassment. At the very least, threats like this are not protected by the First Amendment. It also said this type of harassing behavior isn't protected by the First Amendment. It's a major opinion that fits with what I'm saying. The need for the First Amendment to develop standards to deal with bullying and harassing. But how to draw the line between what speech is protected by the First Amendment and what's unprotected by bullying and harassing is a challenge for the First Amendment jurisprudence of the 21st century. A third challenge for speech in the 21st century is the problem of foreign influence. I already talked about a benefit of the internet and social media and that it doesn't respect national boundaries. But there's also a real problem. Foreign governments, foreign corporations can use social media to try to influence the outcome of American elections. We saw this in 2016. There is no doubt, it's been documented by Special Prosecutor Robert Mueller and by congressional committees, that Russia attempted to use social media, especially Facebook, to influence the outcome of the 2016 election. Given how close the 2016 election turned out to be, it's quite possible that the Russian influence was decisive. But how do we deal with this consistent with the First Amendment? Now, it's worth noting that the United States government has often tried to influence the outcome of foreign elections. Carnegie Mellon professor Dov Levin documented 81 instances between 1946 and 2000 where the United States government tried to influence and determine the outcome of foreign elections. It makes it harder for the United States to condemn this, but it's more difficult than just whether we're being hypocritical. The United States Supreme Court has repeatedly said that the source of information doesn't matter in terms of First Amendment protection, that the government can't, in regulating speech, discriminate among speakers, that speech has value regardless of where it comes from, and then we have to decide what weight to give it. In First National Bank of Boston versus Bellotti, the Supreme Court considered a Massachusetts law that limited the ability of corporations to spend money with regard to campaigns as to ballot initiatives. The United States Supreme Court declared this unconstitutional, and the court said, we protect the right of corporations to speak because the more speech that exists, the more that's there in the marketplace of ideas. The more speech that exists, the better informed people will be. It doesn't matter who's the speaker. The Supreme Court relied on this in Citizens United versus Federal Election Commission in 2010. There, the court declared unconstitutional provisions of federal law that limit the ability of corporations and unions to engage in election-related speech before primary and general elections. Justice Kennedy's majority opinion echoed First National Bank of Boston versus Bellotti in saying, speech is protected regardless of the source. Speech is protected because the more expression, the better informed people will be. How in light of this do we then say that we're going to limit speech from foreign countries or from foreign corporations? Now, there's one way in which we already do this. Federal law prohibits foreign governments, foreign individuals, foreign corporations from contributing money to candidates for federal elective office. But what about other efforts by foreign corporations or foreign governments to influence the outcome of American elections? I've often thought that the solution might be disclosure, to have clearer disclosure of the source of the speech. And yet even that's problematic. July of 2021, in American for Prosperity v. Spanta, the Supreme Court struck down a disclosure requirement that's applied to not-for-profit corporations. Also, the Supreme Court has held, in cases like McIntyre versus Ohio Election Commission, that there's a First Amendment right to speak anonymously, a First Amendment right to speak without disclosing one's identity. In light of this, how do we deal with the problem of foreign speech? To be clear, I'm not talking about when a foreign government hacks into a computer, as Russians did with regard to the Democratic National Committee computers. That's a crime. What I'm talking about is speech from a foreign country over American social media that's designed to influence the outcome of the election. How do we begin to deal with this? This, I think, is one of the real challenges facing free speech law in the 21st century. Fourth, we have to deal with the reality that control over information is in relatively few hands. Companies such as Google, Facebook, YouTube, so dramatically control the information that most people receive. In preparing for this talk, I did some research, and there's estimates that say that 1/3 to 1/2 of all Americans get their news through Facebook. 69% of Americans get at least some of their news through Facebook. 69% of Americans are on Facebook, and most say that they get a good deal of their news through it. 81% of Americans are on YouTube. Well, think about what this means in terms of the underlying values of the First Amendment, in terms of access to information. If Google doesn't make available access to a website, isn't it almost like that website doesn't exist at all? Google is so dominant as the search engine. If Facebook bans someone, then their ability to communicate is so dramatically limited, with 70% of Americans on Facebook. Google, Facebook, YouTube, maybe just a few other companies too, have such dramatic ability to control what we all see and hear. How do we reconcile that with the First Amendment? They, after all, are private companies. They don't have to comply with the First Amendment. About a year ago at this time, we saw Twitter and Facebook ban Donald Trump from being on those platforms. Trump has sued and said that he thinks this violates his First Amendment rights. I think that argument is weak, maybe even frivolous. Facebook, Google, YouTube are private. They don't have to comply with the Constitution. I do not think there's a plausible argument that they are state actors. Former President Trump's argument is that these platforms cooperated with the Center for Disease Control to disseminate information. But it's clear that such cooperation is not enough to make them state actors. And yet I was deeply troubled when Facebook and Twitter banned Donald Trump. I wrote an op-ed a year ago at this time for Bloomberg News about this. I was clear that I wished that Donald Trump would be quiet, and I certainly didn't like the lies that he was spreading. And yet I also don't like Facebook, Twitter being able to ban anyone's speech. There were millions of people who wanted to hear what Donald Trump said. And the idea that these companies could cut off access, could eliminate the message, to me was inconsistent with the underlying values of the First Amendment. There used to be concern that 3 broadcast networks, ABC, CBS, NBC, controlled so much of the broadcast media. But that pales in comparison to the ability now of Google, Facebook, Twitter, YouTube to control what people see and hear. How do we deal with that? I don't think it's through the First Amendment, as I've stressed, they're private companies. Is it by changing federal law? Section 230 of the Communication Decency Act of 1996 provides protection from liability for platforms as this, so long as they're not themselves producing the content. Should we change Section 230? And if so, how? Democrats and Republicans have very different perspectives about this. Do we change Section 230 to create more liability? Or do we change the law to prevent these platforms from excluding particular speakers? And what can we do with regard to Section 230 consistent with the First Amendment? I do not have answers to any of these questions, but I am convinced that free speech in the 21st century needs to deal with the reality of how much information is controlled by relatively few hands. Maybe antitrust is the solution. Some have suggested it. Perhaps it's changing our doctrines with regard to state action. Maybe it's modifying Section 230, but we have to face this. A 5th challenge that we face with regard to free speech, I will call doctrinal incoherence. I began by talking about what was free speech law in 1922. Thankfully, in 2022, we have a far more robust and elaborate set of doctrines with regard to free speech. But there are so many places where those doctrines are just incoherent, where the Supreme Court desperately needs to clarify the law for the 21st century. Let me give you the most simple of examples: the levels of scrutiny that are used with regard to free speech cases. I've always taught my students that there are 3 levels of scrutiny used in constitutional cases. You've got strict scrutiny, you've got intermediate scrutiny, you've got rational basis review. And yet, on July 1st of 2021, in Americans for Prosperity versus Bonta, Chief Justice Roberts, writing for the plurality here, said that the appropriate test to be used in some First Amendment cases is, quote, exacting scrutiny. Well, you then have to read his definition of exacting scrutiny. He says exacting scrutiny means that the government action has to be substantially related to a sufficiently important government interest. That's a verbatim quote, substantially related to a sufficiently important government interest. But how is that different than intermediate scrutiny? The traditional definition of intermediate scrutiny is that the government action has to be substantially related to an important government interest. Putting sufficiently before important doesn't really add anything. Why did Chief Justice Roberts create this test, exacting scrutiny? And then as I went and looked back, I saw there's other cases that use this language of exacting scrutiny. I think this is an example where we need clarification from the Supreme Court in the years ahead in the 21st century. But there's so many other places where there's doctrinal confusion with regard to the First Amendment. If you studied free speech law, you know the line between what's a content-based restriction and a content-neutral restriction is often decisive in the outcome of cases. Content-based restrictions have to meet strict scrutiny. Content-neutral restrictions only have to meet intermediate scrutiny. But the court has hardly been clear in defining what makes something content-based as opposed to content-neutral. Or another example, the Supreme Court, in dealing with the issue of First Amendment rights of access to government property, has created categories. One category is for public forum, another is for designated public forums, another is for limited public forums, another is for non-public forums. But when it comes to some of those distinctions, there's little guidance from the Supreme Court. As an example, what's the difference in a designated public forum and a limited public forum? I can tell you what the Supreme Court has said. A designated public forum is a place that the government doesn't have to open to speech, but chooses to open to speech. A limited public forum is a place that the government opens only to some speakers or some messages. But in practical reality, I can never figure out what's the difference between those two categories. I could give other examples, but as we think about what the Supreme Court's going to need to do for free speech in the 21st century, it's deal with that doctrinal incoherence. Sixth, as I look ahead to the 21st century, I'm concerned about the Supreme Court using freedom of speech to strike down progressive laws. One scholar referred to what's going on as the Lochnerizing of free speech, using free speech to strike down progressive laws in a way that due process might have been used to strike down progressive laws a century ago. Or as Justice Elena Kagan said in a dissenting opinion, it's about the Supreme Court weaponizing the First Amendment. Let me give you a couple of recent examples of what I mean here and talk about their uncertain implications as we think of free speech in the 21st century. Both came down that I'm going to talk about in June of 2018. One was Janus versus American Federation. In 1977, in a Bood versus Detroit Board of Education, the Supreme Court held that the government can require that non-union members in a public employee workplace pay the share of the dues that go to support the collective bargaining activity of the union. The Supreme Court explained that non-employees, non-union members benefit from the collective bargaining of the union. They benefit in terms of their wages, their hours, their working conditions. And this was the law for over 40 years. No one is obligated to join a public employees union, but non-union members couldn't be free riders. They have to pay the share of the union dues that go to support collective bargaining. But in Janus versus American Federation, the Supreme Court 5-4 declared this unconstitutional. Justice Alito wrote for the 5 conservative justices then on the court. Justice Kagan wrote for the 4 liberal dissenters. It's where she talked about the court weaponizing the First Amendment. The Supreme Court overruled Abood versus Detroit Board of Education. The court held that non-union members can't be forced to pay the share of the dues that go to the collective bargaining activities. But how much further is the court going to take Janus in striking down laws that regulate aspects of the workplace? And there are so many that are pending now in the lower courts. There's, for example, the issue, can unions decide to only bargain for their members? Can there be member-only bargaining for unions? Do non-unions members have a right to bargain on their own? Or does taking that ability from them violate the First Amendment? What about charter schools? To what extent does the First Amendment apply in that context and provide limits on the ability of the companies that own charter schools to do things like discourage union organizing activity? Or another example from that same month in the Supreme Court, a case called NIFLA versus Pasera, the National Institute of Family and Life Advocates versus Pasera. It involved a California law that said that reproductive health care facilities needed to post on their walls that the state of California made free and low-cost contraception and abortion available to women who cannot afford it. Also, facilities that weren't licensed by the state had to post that they were unlicensed. They didn't have a license to provide health care. The California legislature documented this was necessary because there were a number of facilities affiliated with religion that presented themselves as reproductive health care facilities, but they existed solely to discourage women from having abortions. Now, as I said, all that was required of these facilities, they had to post a notice. They had to post a notice that the state would provide free or low-cost contraception abortion. If they were unlicensed, They just said opposed they weren't licensed to provide health care. Nonetheless, the Supreme Court declared this unconstitutional in a 5-4 decision. Justice Thomas wrote the opinion for the court. He said, this is compelled speech. He said, compelled speech has to meet strict scrutiny. Now, no one could deny that there's a compelling government interest in letting women know what state programs are available, letting people know when a facility isn't licensed to provide healthcare. But Justice Thomas said, there's other ways that the government can achieve its goal. He said, if the state wants to inform people that it will provide free and low-cost contraception and abortion, let it take out billboards and public service announcements. And he said, there's no proof that women don't know which facilities are unlicensed. This conceivably puts every disclosure law in jeopardy. Because whenever there's a requirement for disclosure, there's always another way to convey the information. San Francisco adopted an ordinance requiring sugary beverages to disclose that excess consumption of sugar can cause tooth decay, contribute to diabetes, contribute to obesity. The United States Court of Appeals for the Ninth Circuit, en banc, declared this unconstitutional, focusing on and relying on NIFLA versus Pasera. There are challenges to disclosure requirements of all sorts now pending in the lower courts. To me, this is about the Supreme Court using speech to strike down progressive legislation. With the conservative court, I have to ask, how far will the court go in this direction in the 21st century? Seventh, and finally, as we think of free speech in the 21st century, I want to talk about a very different context. I want to talk about what I see as a waning commitment to free speech, at least in our schools and among our students, and maybe in our society. Let me give some examples of this and then talk about why I think it's relevant to what I'm discussing today, the challenge of free speech in the 21st century. In September of 2017, a conservative group called the Patriots was going to organize Free Speech Week on the Berkeley campus. And they said they were going to invite conservative speakers, Milo Yiannopoulos, Ben Shapiro, Charles Murray, and others to come speak that week. In anticipation of this, the chancellor at Berkeley, Carol Christ, convened a campus-wide forum, the topic of free speech on campus. It was held in a large auditorium. Every seat was taken. People were sitting on the floors, the aisles. One of the first speakers on the panel was a professor on campus. And he said that the largest problem in our society is white supremacy, and that the chancellor should exclude white supremacist speakers from coming onto campus. There was resounding applause. During the question and answer period, one of the students stood up and very eloquently said, I feel threatened when there are hateful speakers on campus. I want the chancellor to stand up for students. I want the chancellor to exclude hateful speakers like these, no matter what the courts in the First Amendment say. There was resounding applause for the student. The chancellor had kindly invited me to be a member of the panel, and I then spoke and I said, let's be clear. If the chancellor were to exclude these speakers, she would get sued and she would lose. For example, when Auburn University excluded the white supremacist Richard Spencer, his supporters sued the university. They won. I said, very least, the campus would be liable for attorney's fees for the excluded speakers. But even more, the chancellor might be personally liable for money damages because she's violating clearly established law that a chancellor should know. I said, nothing would be gained. These speakers would still have the right to speak. At the same time, I'm getting codes that I'm losing internet. If there's any problem with the internet, let me know. Is everything okay?
I can still see
Is everything still okay? Because I got a message saying I have to sign up.
We can hear you.
Okay.
Yep.
Thank you. I apologize. I got Zoom messages saying that my session was ended. I said nothing would be gained by excluding these speakers. They would speak anyway. We would just be making martyrs out of them. No one applauded when I said that. It's clear in that audience that the overwhelming sentiment was that the campus should exclude speakers that are deemed hateful or very unpopular, even though that's not First Amendment law at all. Or another example, again, just from Berkeley. In November 2020, Ann Coulter came to speak on campus. This was an event on the larger campus, not as part of the law school. As people went in to hear Ann Coulter, they were assaulted. Some had things thrown at them, some were spit at, some had water thrown at them, some were pushed and shoved and knocked down. The next day, I was shown video of this by some of my students who attended. I put out a message to the campus community in which I said that on a college campus, all ideas and views can be expressed. If we don't like speech, the response should be our speech, more speech. But it can't be to silence speakers or to assault the people who go to hear such speakers. I said, we as a law school have to stand up for free speech. It's certainly completely appropriate to protest against Ann Coulter, but it's not okay to engage in this kind of behavior. That day, throughout Berkeley Law School, on every bulletin board, there was posted a flyer criticizing my message. For a time, it may still be there. On the Berkeley Law website, there was a statement by a group of students saying that and this is a direct quote, touted the intellectual acceptability of white supremacist views. I, of course, never touted the intellectual acceptability of white supremacist views. I did say, though, that all ideas and views can be expressed on a college campus. I've taught undergraduate classes on free speech on campus, and I've seen there is simply a waning support for freedom of speech among our students. Maybe that's because this is the first generation taught from a young age that bullying is wrong, and they've embodied the importance of equality. Maybe it's, I think, that sometimes students fail to realize how crucial speech is to advancing civil rights and equality. Maybe the students don't realize the danger of giving to government officials, including campus officials, the ability to pick and choose what speech will be heard and what will be suppressed. But I worry as we go into the 21st century, whether there is a waning of support for free speech, at least among students, perhaps faculty, maybe in the larger society. So I said what I wanted to talk about today to you as part of this wonderful symposium is the future of free speech in the 21st century. And yet as I do so, as I identify the challenges, I have to say I'm far more optimistic about free speech in the 21st century than anyone possibly could have been about free speech at the beginning of the 20th century. We do have robust doctrines developed under the First Amendment to protect speech. Despite what I just said a moment ago, overall, there's a consensus among conservatives and liberals is the importance of speech. What I always try to tell my students is that the only way that my or your speech can be protected tomorrow is to safeguard the speech that we find unpalatable today. We don't need the First Amendment to protect the speech we like. We would let that go on anyway. We need free speech to be there to protect the speech we detest. For me, the most important reason for protecting free speech is a distrust of government and government power. I don't want government officials, the president, the governor, the chancellor of my university, to be able to make determinations what I can hear or read or can't hear and can't read. This is a set of assumptions that the First Amendment is based on, and I'm confident that these assumptions will continue to be followed throughout the 21st century. Thank you again for having me, and thank you for listening. And I apologize for the internet. I just got worried when it said my internet session was about to end.
Thank you so much, Dean Chemerinsky. Not a problem. Zoom comes with always a set of hiccups. I want to open up the Zoom to some questions from our attendees, if that's okay.
Please, I'm delighted to take questions.
Okay. An anonymous attendee asked, Dean Chemerinsky, thank you. You mentioned inherent scarcity in the context of the Red Lion case in 1969, and that there are now infinite possible channels for communication. Does that eviscerate the alternate channel analysis in TPM restrictions, or is that still part of the test courts use?
Sure. What the question is alluding to is when the government regulates speech in a public forum or a designated public forum, the government regulation has to be a time, place, or manner restriction that serves an important government interest and leaves adequate alternative places for communication. And I think that's what the question is referring to in the TPM, time, place, manner, and the requirement for alternative places for communication. I've seen no indication from the Supreme Court or from the lower courts that that's going to change. But if you think about one of the places where the doctrines of the First Amendment are just incomplete is, what does it mean there have to be adequate alternative places for communication? How do we analyze that? Can the government stop speech in a public area by saying, well, you can go on the internet and have your speech? When the issues developed about free speech, Berkeley, someone proposed, well, why don't we just say that they can speak on the Lawrence campus, which is miles away? I said, no, that's not an adequate alternative place for speech. Or some said, well, we'll just allow them to speak via the internet and social media without a crowd drilling. That's not an adequate place, I would say. But I can't tell you what are the criteria for what's an adequate alternative place for communication, because the Supreme Court's never articulated such a test.
Thank you. There is another question from Carlos Cueva Alegria. Apologies for pronunciation. He says, I wonder if there is any distinction in your mind between waning freedom of speech and stopping speech that we know is demonstrably untrue. As an example, we know that the earth is not flat. By banning that speech, what is being lost?
There's nothing in itself that's lost in saying you can't say the earth is flat, but there's also nothing gained by banning the speech that says that the earth is flat. There's no likelihood that people are, at least in significant numbers, believing that. The problem is once we say somebody has the power to determine what's true and what's false, that power is not going to be limited to just statements as to whether the earth is flat or not. Should the government have the ability to punish people who say that the election was stolen from Donald Trump? There's no evidence at all that the election was stolen from Donald Trump. But I don't think that means that people should be silenced in their ability to say that. And so the difficulty in giving the government the power to censor speech that's false is they then get the power to decide what's true and what's false. And that's very frightening to me.
Thank you. We have a third question from an anonymous attendee. It says, thank you, Dean. Justices Thomas and Gorsuch have sent signals about the possibility of overturning New York Times versus Sullivan. What potential ramifications could we see if this case were to be overturned?
New York Times versus Sullivan is one of the most canonical of all free speech decisions. If you ask me to pick the single most important case decided by the Supreme Court about freedom of speech, I'd pick New York Times versus Sullivan. It was a 1964 case. It arose out of the civil rights movement, and it involved an ad that was taken out in the New York Times criticizing white sheriffs in Alabama. The ad contained very small inaccuracies. A lawsuit was brought under Alabama law, and the New York Times was held liable. And the Supreme Court held that there can only be liability for defamation when the plaintiff is a public official running for public office if it can be proven that the statement was false and that it was uttered with actual malice. That is, the speaker knew that it was false or acted with reckless disregard of the truth. Justice William Brennan wrote the opinion for the court and said, it's so important that free speech be protected so we can have an open and robust debate about this hold and run for public office. He said, we have to tolerate caustic, even vituperative attacks on those who hold and run for public office. I was stunned when in a case called McKee versus Cosby, Justice Thomas, in an opinion respecting the denial of certiorari, urged reconsideration of New York Times versus Sullivan, said it can't be reconciled with the originalist understanding of the First Amendment. And now Justice Gorsuch has joined him, also from an originalist perspective. I hope that there is not now and never would be a majority to overrule New York Times versus Sullivan. It's so essential that our media be able to aggressively cover those who run for government office and hold government office. This is where we really do need the breathing space to tolerate occasional falsity. Obviously, if New York Times versus Sullivan is overruled, the impact will depend on what test replaces it. Donald Trump, running for president in 2016, wanted to make it far easier for those who run and hold for government office to sue for defamation. There would be a huge blow to American democracy.
You have one more from an anonymous attendee, and says that you discuss the necessity of allowing disagreeable and distasteful speech in our society and the importance of responding with our own speech in kind. How would you fundamentally differentiate this from Holmes' marketplace of ideas concept?
In one sense, they're quite similar, and they're both explaining why we should accept untruthful and distasteful speech. But there is a key difference between what Holmes was arguing and what I believe. I think what Holmes was saying is we should have faith in the marketplace of ideas, that if false speech is uttered, let there then be true speech, and it will refute it, and ultimately truth will emerge. I don't believe that. I don't think that necessarily truth will emerge, and I think that there'll be instances where there'll be tremendous harms before it does. My argument is based on something else. My argument is based on a deep distrust of government power. And I don't want the government to be able to control what you or I hear. As I said in response to the first question, I don't want the government to be able to say that this is true and this is false. Might the government then say that unless there's a particular view expressed with regard to the status of the fetus before conception, that's a false view, and suppress speech that might be used to advocate reproductive choice for women? Might the government that opposes affirmative action suppress certain speech about the need for affirmative action in order to achieve diversity in light of the history of discrimination? I'm so afraid of giving the government that kind of power. So I don't defend this because I believe that truth will necessarily emerge. I defend this because I don't want the government to have the power to decide what's true and what's false and censor that which it deems to be false.
Thank you. We have a question from one of our panelists from this morning's panel. Oh, sorry, not seeing the chat. Oh, Professor Darren Hutchinson said that he agrees with robust speech occurring on college campuses, but in our society, restrictions on speech can facilitate group subordination, like banning anti-racist activism. The exercise of speech can do the same. For example, white supremacist organizing. Can't we acknowledge this by conceding the danger of Ann Coulter while embracing her right nonetheless? In other words, is it possible to validate the students who protested Coulter to the extent that they believe her speech is part of systemic racism, but still support her right to speak?
Absolutely, yes. I loathe Ann Coulter. Since 1998, I will not appear on any program or panel with Ann Coulter. I very much want to validate the students who protest against her, but there's no right to silence a speaker. So there's no right to engage in physical assaults against those who are going to hear Ann Coulter. And that's what occurred in this instance. Literally, it was physical assaults in the ways that I described. So in answer to your question, I think that campus administrators have an obligation to condemn hateful speech and to express the type of community they want to live in and want a university to be. And so I think it's absolutely appropriate to condemn Ann Coulter. But at the same time, I have to condemn those who engage in physical assaults on those who are going to hear her.
Thank you so much. There's a few more questions in the chat. You have, there's one all anonymous. I'll just read them. Building off of what happened in Mahanoy School District versus BL, what type of framework would you recommend school officials apply to situations where a student posts offensive or racist speech online over the weekend to a limited set of social media followers? Do you think it matters if the speech is targeted at current students or if it could be construed as bullying?
I want to go back to the prior question. And in response to it, I stressed the importance of school officials using their own speech. And so if I heard of racist speech being sent over social media, I would want to respond to that. I would want to explain why it's detestable. I would want to explain why it's inconsistent with the community we want to be. I think my silence would there send an inappropriate message. In terms of punishing that speech, a great deal is going to depend on its content. If its content is racist ideas, then the most that I can do is what I just said, or organize events where counter messages are delivered. And campuses can do that as well. When the white supremacist Richard Spencer appeared at Texas A&M University, a large counter demonstration was organized in the football stadium there. I've talked to some who were present to talk about how effective it is. Now, there's a point at which, in your hypothetical, the speech crosses from expressing racist ideas to being targeted at individuals. And at the point at which it's targeting individuals, then it seems to be closer to harassment. Now, we don't have a very good definition yet for when speech becomes harassment. This is one of the challenges of the 21st century. But I think that part of what's involved here is if the speech is targeted at somebody and would reasonably interfere with their educational opportunities, then it's not protected by the First Amendment. And then the school can discipline it, even if it occurs over social media, even on the weekend. And Justice Breyer's opinion was clear that there isn't absolute protection for speech over social media over the weekend, that there can be punishment if it rises to the level of harassing, bullying, cheating. But we need in the years to come is a much clearer set of criteria for when does speech cross the line and when can it be punished on these grounds.
We have about almost 10 more minutes, so I'm going to try to get through as many questions as we can.
Okay, I'll try to be brief.
No, it's okay. There's quite a few. So my question is a bit sloppy, but the gist would be this. In your opinion, what would it take to rein in the effects of Citizen United?
A different Supreme Court. I don't see any likelihood that the current court is going to reconsider or overrule Citizens United. Citizens United was 5-4 split along ideological lines, and the current court is even more conservative along those ideological lines. I don't foresee a constitutional amendment to overturn Citizens United, though they've been proposed. In part, it's just so very difficult to get a constitutional amendment ratified, 2/3 of both houses of Congress, 3/4 of the states. Also, I think there's an understandable, even laudable reluctance to amend the First Amendment. So I think we have to live with Citizens United until sometime in the future there's a different Supreme Court. But and it's beyond the scope of this presentation. I think there's a lot more that government can do to regulate corporate expenditures in elections than have been done so far. And there are many techniques, I think, that need to be explored that haven't. Most important, we need much stricter disclosure laws to deal with so-called dark money in elections.
Okay, two more. Oh, third one popping up. I'll do as many as I can. States and localities have been taking steps to ban critical race theory in the educational context. Do you think that federal courts will strike these laws down as impermissible viewpoint discrimination?
Yes, I think so. And most of all, I hope so. I think that these laws are most vulnerable on vagueness and overbreadth grounds. If you read the statutes that have been adopted, they're so incredibly vague and overbroad in terms of what they're prohibiting. I should say here, I was involved as a lawyer in a case about 6 years ago. It involved an Arizona law that prohibited the teaching of ethnic studies. And it was very much a precursor to the current laws prohibiting teaching of critical race theory. And it was specifically to target teaching of Mexican immigrant studies, and especially in the Tucson schools. And the district court had dismissed a lawsuit challenging this. And I represented the students and teachers and civil rights plaintiffs and prevailed in the Ninth Circuit. It's a case called Arce versus Douglas. And ultimately, the law got declared unconstitutional. So I think there is hope for challenging these. There's a law now pending, lawsuit now pending, brought by the ACLU, challenging the Oklahoma law prohibiting teaching of critical race theory. So I think there's real hope. And I think these laws should be struck down, especially on vagueness and overbreadth grounds.
We have a question from one of our students, Liza Sternick. She says, President Trump vilified the media and continues to do so. How do you believe the claims of fake news impacts free speech? Would you consider Trump's actions to be a suppression of free speech?
I think that Donald Trump, as president and now as a private citizen, has the right to condemn fake news. I worry that his doing so, especially as president, undermines confidence that people have in the media. The reality is there are facts and there are falsehoods. And if there's no distinction between the two, it's hard to imagine a democracy or any society functioning. So Donald Trump has the right to say this, but I do think his declaring that it's fake news when he disagrees is dangerous for speech, but that's his First Amendment rights.
Last question. To your point of targeting individuals, can you speak more to when speech becomes harassment? I recall when Milo Yiannopoulos was meant to come speak on Berkeley's campus, as you mentioned, he was intending to expose the names of undocumented students who were attending UC Berkeley. How do we address something that has not happened yet, but is teetering on the line of harassment?
It is such a great question. And it really is part of what we need the law of the 21st century to deal with, because we don't have it. We know through social media, it's possible to reveal things, the doxing here, and that there was the real danger that Milo Yiannopoulos was going to disclose who were undocumented students, or he threatened to disclose who were trans students and the like. Now, the usual answer of First Amendment law and tort law is, well, when that goes on, there can be a civil suit for invasion of privacy. The tort is public disclosure of private facts. But the last thing that somebody who's had private information revealed would want to do is bring a lawsuit to call more attention to that private information. The California Supreme Court has said, if somebody has engaged in false defamatory speech, there could be an injunction against that being expressed in the future. It's a case of the California Supreme Court involving a woman in Orange County, Annie Lemon. And they said, once you can prove that she said false things before, you can enjoin her from saying it again. I wonder if there's an analogy that once somebody has engaged in certain behavior like that, you can enjoin them from engaging in that behavior again. But I thought a lot about this in connection with Milo Yiannopoulos, and I do think it's a place where the law hasn't caught up with technology and the social realities.
Well, thank you so much, Dean Chemerinsky, for your incredible insights and knowledge. Your words on the 21st century challenges that free speech law has endured, both in general and on campuses, is truly astounding, and I can't thank you enough for sharing with us today. I'm especially moved by your statements regarding the marketplace of ideas and the common notion that truth will avail without ever considering the possibility that a rebuttal to false information may never be made, as well as your point highlighting how much information is controlled by so few hands. I can't think of a more pertinent discussion for today's climate, especially as a law student. I hope that students from USF and beyond, practitioners and scholars may continue to learn from and draw upon your work in the coming years, as we briefly got to do today. Our panelists today have addressed a wide range of free speech issues, even within the confines of education and social media spaces, from addressing critical race theory in the classroom and the societal values, to LGBTQ issues surrounding free speech claims of misgendering students, to race-based admissions and Islamophobia on the internet, all the way to the legal frameworks regarding the state actor doctrine, the obligations of platforms to allow speech, and the solutions moving forward that platforms may follow to protect users. The law and studies of free speech are by no means stagnant. And as we have seen, and as Dean Chemerinsky extensively highlighted, as technology advances, so expands the boundaries and definitions of speech, what it means for that speech to remain constitutionally protected, and what speech can and should be regulated. As we close out our symposium today, I hope that our attendees can continue these significant and meaningful conversations in their own lives, and that our panel experts continue their impactful work so that we may continue to have these discussions around the ever-changing interpretation of our country's first constitutional amendment. I want to briefly thank the people who have assisted me in putting on today's symposium. Without their help, none of this would have been possible. First and foremost, our program coordinator, Kenji Kihano, who has tirelessly worked to make this a seamless and successful event. I would also like to thank Professor Luke Boso, my faculty advisor, whose constitutional law class inspired today's topics and guided each panel throughout the summer and past months. Dean Freewald, who donated her time to help me research First Amendment issues and moderated our social media panel with her extensive knowledge. Thank you to Megan O'Day for all of your guidance and training to prepare for this position. And I would also like to thank my law review board members, especially Amy Metzger, Laura Oda-Jinran, and Alegna Gomez, who have continuously helped with all aspects of today's event. Lastly, I want to thank sincerely our panelists, our moderators, and our keynote speaker, as well as all of our audience attendees who joined us today. There would not be a symposium without an audience, and I'm honored you chose to spend your day with us, even via Zoom. Thank you so much for your time, for your donations, and your continued support of the USF Law Review. We hope to see you all next year, hopefully on campus. Thank you so much, everyone.